In this video, we're going to talk about disclosing information to third parties and when it's appropriate to have a non-disclosure agreement and what to consider in adopting a non-disclosure agreement in those situations. We've already talked about trade secrets and how it's important to take reasonable steps to keep your trade secret information confidential and secret to your company. In many cases, part of those reasonable steps to maintain the secrecy of that information includes using non-disclosure agreements to cover conversations with third parties involving your highly sensitive technical or business information. Let's talk about first some situations where NDAs may not be appropriate. For many entrepreneurs, when you seek outside capital, you have conversations with investors. It's important to note that many venture capitalists simply will not sign NDAs or non-disclosure agreements. That's because they're talking to so many different parties. They simply can't take on the risk of entering into a contractual relationship with all the people they talk to. And quite often, if you ask a venture capitalist to sign a non-disclosure agreement, you'll be showing your lack of sophistication. So it's important to note the venture capitalists you're going to talk to and whether they will consider signing a non-disclosure agreement. In most cases, they will not. Also, many entrepreneurs talk to many third parties at the outset of their entrepreneurial venture, and this is called customer discovery. You're going to talk to potential customers and see if they actually feel the pain that you're seeking to solve. In most cases, you're not going to use NDAs to cover that conversation with customers because it's going to make it too difficult to have the number of conversations you need to have, and in most cases, you're not actually revealing your confidential information when you talk to those potential customers. But there will be many situations where you will speak to third parties, maybe other large companies that are potential partners, maybe people that you're seeking to bring on and actually work with your company. But there will be many cases where you will speak to people and you will be revealing your sensitive information and you will want to have a non-disclosure agreement to protect your company's interests. There are multiple reasons why you may use a non-disclosure agreement, and the reason behind seeking to have an NDA is going to impact what terms you have in that agreement. Not all NDAs are the same. For example, one reason may be that you have information that may be the subject of a patent application in the future, but you have yet to file a patent application. And you want to avoid this conversation with a third party being deemed to be a public disclosure, which could harm your patent rights. That situation may require a relatively basic NDA. There may be other situations where you're disclosing your highly sensitive trade secret information to a third party, or maybe that third party is actually going to be using some of your technical information and performing tests. That situation may require a more robust NDA or a different document altogether. Let's talk about some of the terms that actually matter when you're the disclosing party in an NDA. The first is the standard of care. Most basic NDAs will require the receiving party to exercise reasonable care, or perhaps the same care that the receiving party uses with its own sensitive information. If you're disclosing highly sensitive information, you probably want to raise that standard of care and be particular about what the receiving party can or can't do with your information. Another term that matters is your ability to get injunctive relief. Many people like to put in NDAs, dispute resolution provisions that prohibit parties from running to court and require them to go through a dispute resolution mechanism such as arbitration. As we've talked about in a prior video though, if you're trying to protect your trade secrets and you're worried a third party is going to misappropriate those secrets, you often want to run to court very quickly to seek what's called injunctive relief. So you want to make sure the NDA allows you to seek injunctive relief where appropriate to stop someone from doing something they're not supposed to with your trade secret information. NDAs are also going to specify whether you need to actually mark your information as confidential when you turn it over to the third party, or whether a certain class of information is automatically confidential. In most cases, whether or not the NDA requires you to mark your information as confidential, you want to do so anyway. That's because you really want the other party not to misuse your information. And so you want to make them fully aware that certain information you're giving them is confidential and should be treated as such under your NDA. One last thing is you also want to make sure that the receiving party returns your information at the conclusion of your relationship or your discussions with them, or that they destroy the information and certify the destruction of this. Most NDAs require this, but quite often people forget to follow up on this requirement at the conclusion of your discussions with a third party. As we mentioned before, if a third party, a receiving party of your confidential information, is actually doing tests on your technical information, such that they could create improvements on your technology, you may want to consider including intellectual property language in your NDA. Consider if the third party, the party that you give your technical information to, actually comes up with an improvement or comes up with some new invention based upon the information you've given them. Do you want to have rights? Because the default situation may be that the third party would actually be the owner, or at least the joint owner, of any intellectual property that's created through their use of your technical information. If you want to be the owner of rights to that information, you probably need to include that transfer of rights in your NDA, and you're looking at more of a robust document than just a basic NDA. And one last overarching point about NDAs is you need to understand that NDAs are a contract, and they're a relatively weak way to protect your information. They can be very difficult to enforce. If you're an entrepreneur and you're talking to a large company, and let's say they actually do go ahead and take your confidential information and start using it for their business purposes, what you would need to prove is probably that they did not otherwise already have that information inside their company, and that they did get that information solely from you and misused it. And that may be difficult to prove with a big company. So when using an NDA, understand it's not bulletproof. It's not automatically going to make the party you're talking to comply with its terms. There has to be some level of trust between yourself and the party you're working with. NDAs can be useful to have a signaling effect, to show the party you're dealing with that you take your information seriously, and to help you down the road if you were to actually claim trade secret status in the information you're discussing with the third party. It's important to have an NDA to show, again, that you're taking reasonable efforts to protect your trade secret information. This is a very general overview of considerations to take when you're disclosing confidential information to a third party and using non-disclosure agreements.